Emily, could you start out by helping us understand what is monetization in a legal finance context? Why is it growing, and what is the value that it delivers to the corporations with whom we work?
A monetization is very simply just an acceleration of the cash value of a risk discounted affirmative litigation asset. So a company may have a very large claim that it expects to recover on. It may be a very long duration, 2 to 3 to 4 to 5 years. And the company would like to advance some of that cash today and to use it for other corporate purposes. And we are seeing this very often now with very large corporations who are looking to optimize their balance sheets and use litigation finance to recognize what was otherwise a hidden asset on the balance sheet and bring forward cash on that asset.
So we often get the question, how is a monetization different from an outright claim purchase? And is it the same thing? Can you talk about how they're different and what different problems they solve for clients?
A monetization is simply a financing arrangement where Burford provides a non-recourse investment in the future proceeds of a claim outcome. And so we are taking a passive investment role. We are not taking over any kind of management of the claim. We are just providing an acceleration of a significant amount of the value of the risk discounted value of the future claim outcome. If a claim is transferable, and not all claims are, could sell a claim outright to Burford, we would take over the management of the claim and the cost of litigating, as well as receive all the upside at the end because it's a full disposition. And in theory, if a client wanted a fuller monetization of a claim disposition, a claim sale may allow to have a larger upfront cash realization. By and large, clients are interested in finance monetizations as opposed to claim sales. Even when there's a full asset sale, the company still is obligated to be part of any discovery that needs to be taken. And, the facts of the claim still revolve around the company's participation in the underlying transaction. And so even a full asset sale doesn't allow a company to be completely rid of any responsibility for the claim. And especially when their executives are involved, the company likes to maintain oversight and control of the litigation.
Emily, could you give an example of what a monetization has looked like in practice without identifying the client?
So Burford worked with a Fortune 50 company to accelerate a significant portion of a very large antitrust claim that the company had against multiple defendants. The company saw that there was very strong merits, but also some risk, and there would be a long duration expected before any kind of recovery. And the company believed that it was a significant asset and wanted to move cash forward. And so Burford assessed the litigation, agreed that we thought it was extremely strong on the merits, and was willing to advance $75 million upon closing to the company for a finance investment in its claim in return for, of course, a return for Burford. But the expectation for the client that they will continue to oversee the claim, and if the claim resolves well, the company will also have additional upside from the claim resolution, but it has locked in today $75 million of value.
What does Burford look for when we look at claims, judgments, and awards for monetization?
The biggest factor we look for, and whether it's monetization or any other kind of investment we do, that here in particular, we look for that we have very strong conviction on the merits of the case, and that we have a sense that it's, I like to say, big enough to support a monetization. So, generally it's relatively high value claims where there's sort of loan to value available over and above what's needed to actually finance the cost of the litigation. So, especially early on in a claim where a party's looking for a monetization, where there's more risk in the case pre-trial, we want to feel very strong about the potential merits. Another place that we do a lot of monetizations is after a party wins a trial judgment, either from a judge or a jury. And there, we have a firm amount of what the judgment is, and the risk heading into an appeal is relatively low compared to pretrial. So that's an attractive time because companies have oftentimes spent years litigating, getting to a trial verdict, and it's very exciting to win. But these days, potentially looking at a year to 2 years before an initial appeal is decided, and it can be a long time to wait. And that's a very popular time for companies to seek significant monetizations or accelerations of the value of the trial award.
So looking at it from another side, Emily, when a company has a valuable claim or judgment to monetize, what should they be looking for in a legal finance partner?
Burford's clients that we work with on monetization are looking for partners that have a long track record, have expertise and experience in riding out the ups and downs of a long-term litigation, which even the best case always has hiccups and bumps along the way. And they need a counterparty that has a team that has deep experience to understand that and make sure that they're there to ride out the case all the way until the end. In addition to, a long track record of success in choosing cases and structuring transactions that are beneficial for the client and commercial, and that that there's transparency around where capital comes from, and just having that long track record, I think, is important for clients to know in 5 years that we're still going to be here and we're still going to be invested in the space because this is all we do. We're not sort of either a smaller, newer entrant into the litigation finance market or a multi-strat that's dabbling in litigation finance.